Okay, it looks like the room is now open for people to join.
Okay.
We will be getting started in a few minutes. Thanks for those of you who are signing in. We just opened the room, so we're going to have to give a few more minutes for everyone to get in here, but you should see the cover slide for the presentation. What's in an employment agreement? I'm Scott Horton, and Julie Bastian is also here presenting with me today.
Hello.
So again, we'll just let everyone get logged in. You should have access to a chat room. If you want to say hello, that's where you'll be able to ask questions during the presentation. We'll go over that again just as we get started in about 3 or 4 minutes. So if you are logging in, just make sure you can see the slide presentation, what's in an employment agreement. Hopefully you have access to the chat window, and if you have that and you can hear us, then you are good to go. Just for best performance, try to avoid having too many other applications open on your computer device as you're watching this. Usually the feed is pretty steady, so I don't anticipate any problems, but if you are having any problems, usually the best idea is to limit the competing apps on your computer or whatever device you may be logging in from. All right, so we're going to give a couple more minutes as people are getting logged in, but we're about ready to get going. Again, hopefully you have the chat window. If anybody wants to say hi, just to let us know that that's working, that'd be great. We have the slide up. You should be able to see what's in an employment agreement with my name and Julie's. We will be presenting today. We will be getting started in just a couple more minutes. And for those who are wondering, I will mention it again in just a minute, but you will have access to these slides after the presentation. So we will give you a link to that at the end. And again, there will be a live question and answer at the end of the presentation. I'm just going to give, because we're at our start time, I'm going to give about one more minute, and then we will officially get started. All right, we're just about ready to get started.
Okay.
Here's a good question. I will go ahead and answer that, and then I'll get started following up on the answer. The question about credits for attending, the program itself is not pre-approved for credit. My understanding is that people typically have been able to get credit for listening to these webinars. And at the end, we do send a confirmation email indicating the name of the program and that you attended. And again, you will get a copy of the materials. So again, I can't make any more specific promises than that, but again, my understanding is that in many cases, you may be able to get credit. If you have questions on that after the fact, please let me know. But with that, we're going to go ahead and get started. Our presentation today is on the topic, what's in an employment agreement? To-dos, to-don'ts, and ta-das. So hopefully we'll be able to shed some light on some things that are good ideas, bad ideas, and maybe some tricks of the trade or practice pointers that you haven't already come across. My name is Scott Horton. I am founder and attorney with Horton Law PLLC. We're based just out of Buffalo and Orchard Park, New York. And Julie Bastian, also with the firm, joins me today. You want to say hi, Julie?
Good afternoon, everybody.
So what we're going to do is kind of trade off going back and forth with some of the topics in this presentation. And then at the end of the presentation, we will do a question and answer. We encourage any questions to come in as you think of them, type them into the chat window. In most cases, we will wait until the end of the presentation to answer the questions. But if it's something, that really fits in where we are, we may address it as we go. But regardless, we want you to type it in when you think of it so you don't forget about it. Just keep in mind that even if you happen to be a client of our firm, there's no attorney-client privilege for what's discussed here because there's other people present. And therefore, if you need to have a privileged conversation or something you're discussing is more confidential and specific to your business, then let us do that offline.
Okay.
Okay, so that pretty much covers the basics. Let me go over what the presentation is going to include. We have broken this down into various components that are commonly found in employment agreements. They include the position and job duties, compensation and benefits, term and termination provisions, confidentiality, restrictive covenants, and intellectual property protections. There's a few more things that are also commonly found in employment agreements that we will probably mention as we go through, but we wanted to have a relatively finite number of topics to initially go over. And again, we will take questions at the end.
Scott, are you still there?
Sorry. I'm back. Technical difficulty there for a second. So first I want to talk about the offer letter because not every employee is going to have a written employment agreement for various reasons. And sometimes the only documentation will be the offer letter. There are also situations where there won't even be a written offer letter. Maybe it's by email or maybe it's just an offer conveyed verbally. And Julie, do you still have your mic open? Can you shut it or mute it while I'm talking?
Yep,
Because I'm
absolutely.
getting a little feedback. So when you do have a written offer letter, it's normally a good idea to think about whether there will be an employment agreement. If you are putting certain terms in writing in an offer letter, Obviously, you won't want them to then be inconsistent with a subsequent employment agreement. And it is also possible that your offer letter, if there is not later a written employment agreement, will in effect become an employment agreement. In other words, it will be a written document that might become legally enforceable as an employment agreement. So if either of those things are possible, then you have to take more care in the offer letter. So if you're going to just have an offer letter that's a standalone document that's going to set the basic terms of employment with no written employment agreement to follow, then you want to be a little bit more inclusive in your offer letter. Spell out the basic terms of the job, which should at least include the job title, maybe briefly what the job description is if it's not completely obvious, and some description of what the compensation and benefits are. This would normally not be in specifically legally drafted sections and provisions and numbered clauses format, although it could be. But again, put enough in there, even if it's just references to the employee handbook or existing employee policies, company policies, and the like. The offer letter is also going to be the spot where you're going to, in many occasions, identify any conditional terms that need to be met. That would include things like a background check or a pre-employment physical or drug testing requirements. So, those are things that once the employment actually starts have likely been taken care of, but they're going to be more often in an offer letter than they would be in a later employment agreement. But if you're doing it as all one document, then that would also be in there. Describe the term of the employment. And by term of employment, we are usually talking about generally one of two things, either at will employment, which can end at any time, and we'll describe that a little more carefully later, with or without notice, theoretically, and with or without a particular reason or cause. And again, we'll go into that in another section of this presentation. And finally, if you're going to have the offer letter as a standalone document, it's often a good idea to have the employee sign off on the offer letter. Some of you may have people sign off on the offer letter, even if you're going to have a written employment agreement, and that's not necessarily a bad thing, but it's not 100% critical, especially if you're going to have another document that the person is going to sign at the outset of employment. Okay, so just very quickly before we move on with the employment agreement per se, if you are using an offer letter and then you're going to have an employment agreement, one of the things you might put in the offer letter is that there will be employment agreement to follow, assuming the person accepts the offer in the first place. But you can be a little more generic, perhaps, in those offer letters if it suits the circumstances. Again, the focus is going to be on giving them the basics of what the job is and probably what it pays, as well as identifying any terms that have to be satisfied before they could become employed. And again, one of those terms could be the signing of an employment agreement or other documents that you need them to authorize up front. Now we're turning more to employment agreement per se. Before we do that, I just want to throw up a quick poll and ask you to indicate whether your organizations use written employment agreements. We have a couple different options up here so we can get a little bit more of a feel. So it looks like about what I would expect. There's sort of a race between the two yes answers, either yes, use it for most or all employees, or yes, for a smaller number of employees. And we have about and 1 out of 7 or so saying no. The organization doesn't use written employment agreements. A lot of it's going to depend on what your organization is. There are places like restaurants, for example, where the overwhelming majority of employees might not be signing employment agreements if they're just working in the restaurant, but if they're in management or corporate, then they would. And then there are other more office environments where employment agreements may be more prevalent, but there's really no one size fits all rule as to when to have an employment agreement and when not to. So some of the things to consider, although by no means a complete list, are whether the employees are exempt or non-exempt. That's not necessarily the main factor in most situations, but non-exempt employees are generally going to be hourly. They're generally going to be lower paid. They are going to be eligible for overtime, which needs to be addressed in some way, shape, or form. In New York, for example, you have to give all employees written notice of their pay upon hire, including their overtime rate and whether they're eligible for overtime. So in that case, you have that document, assuming you're doing what the state expects you to be doing. So that might be sufficient and you wouldn't need an employment agreement. Some exempt employees wouldn't need employment agreements or might not have employment agreements anyway as well. The length of the employment is probably the single most determining factor, I would guess, as to whether you're going to have an employment agreement, in the sense that if the employment is going to be at will, then you can have an employment agreement or not. But if you're going to have one of these other categories, then you're pretty much going to need a written employment agreement to document that agreement. And that means that either the employment is going to be for some fixed term that can only then be ended early because of specific circumstances that should be spelled out in the agreement, as we'll discuss, or an evergreen arrangement where the term of the agreement is set, but then will automatically renew until it is canceled based on some parameters, again, that should be written out in advance. The level of the position is another big factor, especially if you're in that category of employment at will. This is probably going to do a fair amount to help guide whether you really need to have an employment agreement in some situations. If you're looking at the higher level executive or managerial employee, then you're going to be more likely than in other cases to use an employment agreement. Whereas if you're at a lower or entry level position, it may be less common. Not to say that there can't be companies that have every entry level employee sign an employment agreement, but it's just much more likely that if you have executive level employees that they're going to have employment agreements, because if nothing else, they're usually more complex compensation arrangements and things like that that need to be addressed in writing up front. And then just another factor, the type of position I already mentioned, a restaurant, a server or chef position, and many restaurants probably isn't going to have a written employment agreement, though not to say they can't. And someone who is working in sales is more likely to have commission arrangement and more likely to need to be subject to some restrictive covenants on not stealing customers and things like that than someone in an operational capacity might be, although again, that's not a specific rule. Someone who is working in an office is going to have access to different types of information and may have different terms of employment versus factory employees. And another factor I didn't put on this slide, but probably should have been, is whether the employee is in a bargaining unit, whether there's a union representing the employee, because if there is, then typically the collective bargaining agreement between the company and the union will be, in effect, the employment agreement for the workers in that unit. However, there's even exceptions to that. Look at the professional sports, for example. Professional athletes are in unions and have collective bargaining agreements that govern their relationships with the league and their employers, the teams, but at the same time, they also have individual contracts that set forth their specific terms of employment. So again, no one size fits all, but those are some of the things that you will be considering. And then once you decide to have an employment agreement, or if you've already made that decision and are reviewing what's in your employment agreement, here are some sort of broad ideas to keep in mind before we break down into the specific components. First, you want your terms to be unambiguous. The point of putting something in writing is to understand what is going to happen, frankly, in the event of a dispute later. So don't leave room for interpretation. Not to say there won't be room for interpretation, but do your best to tie up all the reasonable loose ends or cover the most important part of the topic you're addressing. With that being said, the employer generally wants to retain discretion and flexibility in some areas, which is not always a bad thing for the employee. For example, you're often writing into a contract, especially where the employment is at will, what the starting compensation is, but that doesn't mean that either party intends for that to remain the compensation for the duration of employment, which could go on many years. So, in that situation, the company usually is going to retain the discretion to change the salary, for example, going forward, and then it will be up to the employee whether to accept that salary going forward as it changes or to seek alternative employment as their option otherwise. You're looking, again, assuming you're coming from this as the employer representative, which is the side we represent, the protections for the employer are going to be the main focus, but not the sole focus. I mean, I could write an employment agreement that gives, astronomical protection to the company, all at the expense of the employee, which might initially sound like a decent idea for the employer, but if no one is going to actually accept that employment and sign the agreement, then you're not really accomplishing what you need to as a business because you won't have anybody to do the work. So there is some balance that needs to be gained there. But again, as the company writing the employment agreement, the idea is normally to make sure you're getting the protections that the company really needs under the circumstances. And really the flip side then becomes don't ask for everything that you could possibly imagine because it might be overwhelming to the person you're trying to hire, might send the wrong message, and might turn away people that otherwise could and should be working for the company. Finally, we'll spend some time on the restrictive covenants that are available. One reason I wanted to bring this out up front, you can define restrictive covenants as broadly as you want, but what we're really thinking of here includes the non-compete and non-solicitation provisions that you might have in your agreements. And again, we're going to go in a lot more detail on those. But you could also include in this idea the confidentiality and non-disclosure types of provisions that I'm about to talk about in a few minutes. I just want to point out that there are some cases where it's reasonable to have a standalone confidentiality agreement, maybe where you don't even have a more traditional employment agreement. There are some levels of employees where you don't necessarily need all the bells and whistles of an employment agreement, but they still need to understand that they, have to follow certain guidelines and not disclosing information about the company and whatever. So you may be able to just focus on what you really need in writing without adding in every other component of a traditional employment agreement in certain circumstances. Julie, with that, I think I'm switching over to you for a few minutes.
Yes. Okay. So next we'll talk about position and job duties and what to include in those sections of your employment agreement. Hold on. Advancing for me. Are you able to advance the slide, Scott? Okay, position and job duties. So some of the things that you want to address in these sections would be to state the job title. If the job title isn't obvious, you want to make sure that you're including a broad description of job duties, including examples. What you don't want to do is get locked into the employee saying, well, I'm only responsible for the duties described in my employment agreement. So you want to make sure that you retain the ability for management of the company to modify job duties and the supervisor during employment. I mean, you're more than welcome to include those in the employment agreement, whoever the supervisor is, and the job duties that are currently required for the position, but you want to make sure that you retain the right to change those throughout employment. And you also want to mention whether or not it's a full or part-time position, specifically because if later on we'll talk about the benefits, and if there's a requirement that they meet certain hour limits in order to qualify for the benefit, you want to be telling them up front what the expectation is, if it's going to be full-time and what full-time means versus part-time. Okay, the next slide. Then compensation and benefits. Here it's going to depend again on what type of employee it is and what type of arrangement you have with them, what type of position it is, how you're going to list out the compensation for the employee. And we'll go into the different kinds of compensation and the different types of benefits sections that you might want to have. So for compensation, if it's an hourly employee, you want to state what that hourly rate is. If it's a exempt employee, you're going to stick with the straight time for all hours worked. If it's a non-exempt hourly employee, you would list the overtime rate as well. For the salary, you want to identify whether or not it's an exempt salary position or a non-exempt salary position, and explain that they'll get the full salary for any week in which they work. You want to explain for non-exempt employees how overtime will be calculated so that they understand what the expectation may be. In the next category is incentive compensation. For this one, you want to make sure that you're identifying eligibility requirements and the maximum bonus amount that they might be entitled to. You also want to make sure that you outline conditions that must be met by the employee and the employer if they're part of the incentive compensation. You also want to make sure that you retain management discretion to modify those terms throughout employment. If for whatever reason you want to revamp the incentive compensation structure, you want the ability to do that and change it throughout employment. If there are requirements that the employee must be employed at the time of payment in order to maintain eligibility, you would need to put that in writing as well. And then for commission agreements, you can either include commission agreements, the explanation of the agreement in the employment agreement, or sometimes companies have a separate document that is just about the commission structure and kind of goes into the details of the earning of the commission. In either case, you need to make sure that the commission, especially in New York requires that commission agreement be in writing, and that like I said, it could be either in the employment agreement or in a separate agreement, but it has to be in writing. You want to explain the method of computation for the commission, how they earn it, and the frequency of the reconciliation. So, if it's for a quarterly commission, how do you calculate those commissions and when are those commissions paid out? For New York, they require that the employee sign the commission agreement. So if it's an employment agreement, they're already going to be signing it. If it's a separate commission agreement, that in writing that employee signs, and you have to give a copy of that signed commission agreement to the employee. For stock options, maybe part of your compensation structure, you want to make sure that you're getting into those details. How is the stock earned? What is the rate of the earning of the stock, and what happens to the stock upon termination? So the next one would be discretionary bonuses. And if your company usually gives out discretionary bonuses, you may want to, sometimes it's better to leave these out, these discretionary bonuses, but if for whatever reason the employee is insisting that you document that in their employment agreement, you might want to address and specifically state that it's a discretionary bonus. So next slide. Benefits. So there's a couple different kind of benefits that a company can offer its employees. So I included that all in this slide. The basic concept is that you want to explain any benefits that might be available to the employee and address any eligibility requirements. Some companies just sort of have a section for this and refer to a separate benefits package that might be given to them, a separate explanation of benefits, whether it be the health benefits, your paid time off policy, your vacation or sick time policy, and then retirement benefits. Or you can include and describe these benefits directly in the employment agreement. It's really up to the company what they prefer to do. When it comes to health benefits, you want to provide a brief summary of the plans and specifically what the employee is going to be eligible for. If you have different policies available to certain classes of people, you want to make sure that you're only describing those that the employee is eligible for. That would include medical, dental, life insurance, and any other health benefit policies that you may have. The next one is paid time off or vacation or sick time. I think we're seeing a trend of moving towards paid time off, which includes both vacation and sick time. But some companies still have the separate vacation and sick time policy. This is also based on state law. There are some states and cities that require mandatory sick time. You want to make sure that your policy complies with the requirements under law. If not, if your company chooses to provide the sick time where it's not mandatory, you want to make, you want to include an explanation of how that time is earned, whether or not the time rolls over from year to year, and what happens to the time upon termination. And that goes for all of them, the paid time off, vacation, or the sick time. For retirement, you want to identify if there's a pension program, a 401k or 401(b), and the eligibility for cooperating or joining or contributing to any of these programs. If there's eligibility criteria that must be met, explain that, and any other retirement benefits that your company may offer. Same thing, you want to address what happens upon termination, and I guess any other benefits overall that your company offers. Some people have a policy where they provide money for transportation. Some states require that. Others just provide it as an added benefit. So just explaining, what benefits the employee is eligible for and what those criteria are to meet eligibility requirements. Next.
Julie, I think I'm going to pick up here, and I just wanted to note on the benefits piece. I don't always write out all of the benefits in an employment agreement. It depends. I mean, again, with higher level employees, you're more likely to have more things to address in detail. But some of the typical policies, the hospital, medical, dental, life coverage, even life insurance that just apply across the board to your employees. You're not going to do an exhaustive description of the policy and all the terms in the employment agreement, but I think the take-home point on all these is you either mention that the employee is eligible for these policies subject to applicable and prevailing company plans, or point to the employee handbook or something along those lines. So again, it's not that the employment agreement is not going to be the end all be all on all of these benefits, but normally if you are getting into a written employment agreement that includes compensation and benefit terms, you at least want to reference the other benefits that they would be eligible for. But you don't always want to tie your hands so specifically and say that they're going to get X, Y, and Z health insurance plan, because that might be something that your company reviews and changes periodically. So you could just reference, health insurance pursuant to company plans or whatever.
Okay.
But I think I was going to go into the term and termination provisions, and then we'll get back to you in a minute, Julie. The term of employment is something that I mentioned before can really be a big factor in what you're doing with an employment agreement. An at-will employment is going to lead to usually a more straightforward employment agreement, because if it's not going to be employment at will, then that's something that's going to have to really be addressed in the contract itself. So employment at will means that either the employer or the employee may end the employment at any time for any reason, with or without notice, where the huge caveat these days is that the for any reason for the employer has to be basically a lawful reason. Theoretically, the employer could terminate someone for no reason, but it's almost impossible to have no reason for doing something. And realistically, because of all the laws that protect employees, employers are going to have to be able to explain what their reason was, and it has to be non-discriminatory, non-retaliatory, and that type of thing. But so that's the general concept of employment at will. The point of employment contracts sometimes is to make an exception to employment at will. And that's one of these types of contracts I mentioned before, the evergreen or fixed term contracts. One of the things that's very important in those types of contracts is establishing what the circumstances are in which the contract can be terminated. And the other important thing is what happens when the contract is terminated. Does the employee get money or benefits, or continue compensation, severance pay, or something like that, despite the end of the employment? So that's really what we're going to talk about next. Usually, if you're deviating from employment at will, you are moving into an area that's typically known as termination for cause. If you're going to have provisions saying that the employee can only be terminated by the company for cause, then it is 100% advisable to explain what you mean by cause. Not always done, but especially in an employment agreement with an individual employee, I can't think of a good reason not to at least try to spell out what cause means, because the law really doesn't step in and tell us what it means if you don't define it. It leads to a lot of guesswork and ultimately leaves a judge or possibly a jury in a position of trying to figure out what cause is supposed to mean. Usually, you're going to define cause in terms of things like failure to adhere to the terms of employment or to the terms of the contract, insubordination, other conduct that's harmful to the employer or the company, violation of company policies, which may or may not be specifically identified, Gross negligence or other willful misconduct. Um, Illegal activity is usually considered to be for cause, or at least I should say, usually defined to be for cause. Again, you don't want to assume anything would be considered for cause. You want to spell it out. Again, there's no limit on how you can define for cause. You could say that you can be terminated by the company for cause if you don't show up to the board meeting every third Tuesday of every month. And that could be the extent of your for cause termination provision. That's probably not what you want to have be the extent of your for cause termination provision, but you could write a contract that way. On the other hand, you could write a contract that says for cause means any reason the company wants other than an illegal reason, which would probably really get you back to at will employment. But if that's how you wrote the contract, I think you could make a good case that the company has substantial latitude as they do in the at will employment situation. Really just words on a page. On the other hand, termination with cause, if you are putting it in the contract, is normally going to be whatever isn't termination for cause. So you don't actually have to say that it includes downsizing, reorganization, position elimination, the person not being the right fit for the position. But you can, and it depends on what circumstances you think might arise in the specific situation. A couple things that we also need to address here are notice provisions. So contracts will normally say we can fire you for cause with however much notice, where for cause may allow you to terminate employment with no notice, or it may be less notice than you would have to give in terminating without cause. On the theory that if somebody's done something wrong, they don't deserve as much time to find out that they're losing their job as if the situation where they didn't do something wrong. And then the related consideration is severance pay. If you're terminated without cause, sometimes you will be entitled to severance pay, whereas if you're terminated for cause, then you will be deemed to have essentially forfeited your right to any severance pay. But again, all of this is how you write it. I've seen tiered structures where there's really more categories than for cause and without cause. It's something like if we terminate you for cause with this much notice, then this is what you get. And if we terminate you for cause with less notice, then this is what you get. And if we terminate you without cause, then you get more, unless we give you a certain amount of, so there, again, there's all different categories. But that has to be thought through as you're preparing your agreement. And again, this is something that is often not going to be one size fits all for every employee in the organization. Most companies are going to have at least some employees who are going to be employed at will, and many organizations are going to have some employees who have a term of employment subject to some of these termination provisions. I put on this slide, because we're not addressing it at length anywhere else, the possibility of arbitration clauses. Many employment agreements have historically had provisions saying that if there's any disputes over the employment or the agreement, then they will be decided by arbitration, and you can spell out a lot more details and parameters on that. There are really a lot of factors that go into whether it's a good idea to require employees to agree to arbitration. So it's probably a separate presentation in itself. A lot of it depends too on the nature of the company, to some extent what state law says, although there's federal law that might preempt state laws. But we're in New York, where we now have a law that says that certain harassment claims under state law can't be subject to mandatory arbitration clauses, which may or may not be an enforceable statute. But so for a lot of reasons, we're not addressing those there, but you should give consideration one way or the other before using those arbitration clauses in your employment agreement. And again, there's a lot you can do with them, different ways you can write them. There's issues of class action waivers with arbitration clauses. It's just a very hotly contested legally and publicly issue these days that we wanted to mention. You can also address employee resignation. So the termination provisions are not just one-sided. They can also address what the employee is obligated to do. Usually the company wants the employee to give a fair amount of notice that they're going to leave the company. All else being equal, most employees wouldn't mind being able to just get up and walk out whenever they choose. I think custom and practice has sort of established that people should, in most cases, give some reasonable period of notice, normally ranging from a week to a month in most cases, with 2 weeks probably being the most standard rule of thumb. But if you're going to have termination provisions in a contract, you should be considering what the employee's expectations or obligations are on that side of it. This can also play into what, if anything, the employee receives upon leaving. Severance pay, for example. So if they don't give proper notice, they may forfeit some of the severance pay they might have otherwise been able to receive. One note here is that most likely you're not going to be able to require an individual to continue to work for you during the term of the employment. So if the contract says they're supposed to give 30 days notice and they say, I quit and I'm not coming back tomorrow, you're not going to be able to go to court and get them legally compelled to work for your company for the next 30 days. There are laws and constitutional amendments that prohibit that type of involuntary labor, as you might understand. But there might be other consequences of them doing that. It might tie into some ability that they have to go work another job or not, as we'll talk about. All right, I'm going to talk about confidentiality pretty quickly and then move on to Julie to go into the restrictive covenant. So again, I mentioned confidentiality and non-disclosure provisions can be considered restrictive covenants in certain ways. They're, in a sense more restrictive, in another sense less restrictive, right? So what your confidentiality provisions should do is identify confidential information in the company or explain generally what that's going to include, and then tell the employee and have the employee agree that they can't disclose that confidential information to third parties, or they can't use it in future employment, and things like that. Obviously, they have to be able to use the company information in pursuit of their duties for the company. But you can put specific restrictions and say that, your department is not allowed to share this information with another department. That's not the most common confidentiality provision, but you can imagine a company where, research and development has access to information that doesn't need to be shared with sales and marketing or production, for example. These provisions normally are for an infinite duration, in the sense that once I have access to the company's trade secrets and proprietary information, I shouldn't be able to quit the job and then go tell somebody else. So it lasts beyond employment. That's not to say that if 30 years later you disclosed something that at the time you worked there was a former employer's trade secret, that you would necessarily be held liable for breaching the agreement. But normally these things are written to have theoretically infinite duration, and if it was ever challenged, it would probably depend on whether that information was actually still confidential, proprietary, or somehow still valuable to the company that generated it in the first place. Related to this, you can put in reasonable requirement that the person return all information and property upon the end of employment. So if you have electronic records or paper documents or whatever, employees should be returning all of that in every form and not keeping any copies at the end of employment. In some cases, you might not care. It might be copies of things they have that are completely harmless and you don't really want them to dump it all back off on you. But it's normally best to address that in these agreements. So when the end of employment comes, especially if there's any dispute or any unhappy feelings at the time, you have something to point to and aren't just relying on the person agreeing to give you back everything you say you want. Just be careful in writing confidentiality provisions. Again, with all of these employment agreements and clauses, it's not unusual to get one from somewhere else, cut and paste, borrow, use the parts you like and whatever. And that's probably generally a bad idea. But with the confidential information, if you do that, if you just borrow somebody else's confidentiality provision, confidential information might be defined to include a whole bunch of things that don't actually apply to your business. They might, pertain to technical drawings and blueprints where your company is a retail business and you don't really generate that type of information. Or it might be referencing customer lists and things of that nature when your business, for whatever reason, doesn't refer to customers but refer to patients, because let's say you are in the medical field. So you should be cautious about those things, but definitely include examples of the types of information while at the same time leaving the language relatively open-ended. Again, there's a lot more detail you can do with this. If there's very high level concerns, then you would want to spell that out. In some cases, there should be actual procedures in a company for classifying, possibly even literally stamping the word confidential on documents. And you can even identify that in the employment agreement, basically saying that you have access to information, but if you see this label, then you no longer have access to that information. And if you try to access that information, you will be in trouble. But again, that's a case-by-case situation. Breaches of confidentiality obviously can be problematic. What's going to happen in the case of a breach of confidentiality? Well, it's going to depend on different things, but you can address that in the agreement depending on the level of concern. You could theoretically put in provisions saying that if you breach this, you're going to owe us certain monetary damages. Obviously, it's usually going to say you can be disciplined, but you can imagine if you're one of the employees who has access to the secret formula for some, popular beverage or other consumer product, and you were to steal that and take it somewhere else, the damages to the company could be considerable. So, you would focus more on that than in some cases where it's unlikely that the person is going to be able to do that much damage. In those cases, it's that much less likely that you're actually going to try to enforce through a lawsuit the breach of confidentiality as well. But again, these are things you should be thinking about as you're preparing these documents up front. And with that, Julie, I'm going to switch back to you.
All right, thank you very much. Okay, so the next one is restrictive covenants. And you may or may not include provisions about restrictive covenants depending on the type of position and whether or not exempt versus not exempt and the actual job duties required in the position level of employee. But if you're going to, here's 4 of the main types of restrictive covenants that we most often see in employment agreements. Could you please advance it? Okay, so we've got 4 of them. It's non-solicitation of employees, non-solicitation of customers, non-competition, and non-disparagement clauses. So with non-solicitation of employees, that's preventing the employee upon termination from soliciting in any way current employees of the employer, or, and sometimes they'll make it retro, so employees that have been employed within the last year of employment, something like that. But the goal is that you don't want that employee, when they terminate, to go to another employer and then solicit current employees that you're doing business with. And a violation of this might be a contractual interference with a existing relationship. The next one is non-solicitation of customers. Same thing, that prevents a departing employee from going to a competitor, really, but could be anywhere that they go, and they solicit business from one of your current customers or a potential customer that the employee was aware of that the company was going after. And the idea here with the non-solicitation of customers is that you want to be able to protect trade secrets, confidential and proprietary information. And the last thing you want is an employee going to a competitor and using the information learned during employment, especially your customer list, and then going after your existing customers or potential customers that you are going after. The next one is non-competition. That's obviously the biggest one that most companies worry about. And that's going to prevent an employee from going to a competitor within a certain geographic area within a certain amount of time, and using that information that they learned during employment to compete against your company. We'll get into more detail about the non-competition agreements in a second, but that's generally speaking what the goal is of the non-competition agreement. The next one is non-disparagement, and that would be where you're trying to prevent a departing employee from, saying any negative remarks about the company or the employees or officers of the company, because, for whatever reason it might be that the employee is doing it. It could be to solicit business for their new company, or because they departed on unfriendly terms and, they want to sort of trash the company or the employees of the company. Go to the next slide, Scott. So consequences of a breach. The agreement should explain what may occur in the event of a breach of any of the restrictive covenants. And this could include discipline up to including termination. And some of those, that non-disparagement clause might be a requirement of employment as well as post-termination, and monetary damages. Sometimes the sections will require the employee to reimburse the employer for any attorney's fees incurred as a result of breach. So an example would be the non-competition agreement. If the employee goes to after they terminate, they go to a competitor, and especially if you feel like they're using any confidential information that they learned during employment, you're putting this language in your employment agreement to require them to reimburse you if the company feels they need to seek litigation or pursue the breach further, whether it be they were looking for an injunction or monetary damages. And if they're retaining an attorney to assist with this piece, you want to go after the employee for the reimbursement for the cost of those fees. Next one. So covenants not to compete. So these are difficult to enforce. It varies significantly based on the state where you're doing business or the state of applicability. So you want to make sure that you're researching what the law is in your state and make sure that you've met the criteria required in order to make that covenant enforceable. And then you retain the ability to modify that during employment. The main thing that courts focus on is the geographic scope, the duration, the definition of a competitor, and the protection of a legitimate business interest. So you can't just prevent departing employees from working anywhere or working for a competitor unless you're trying to protect a legitimate business interest. Usually that business interest is, again, your trade secrets, your confidential information, your proprietary information that they're taking and going to use at a competitor and use against you. So it's obviously going to give that employee a little bit of an advantage over other employees of the new company because they've already had their experience and what they learned while employed at your company, and now they're taking that and using it at a competitor, which may, it may end up with the employment may end up giving negative effects to the employer because they could be taking away from customers. Maybe you were looking at a new business idea and we're going to roll that business idea out in the next month, and the employee terminates and they go to another competitor and disclose all that information to the competitor, and then that competitor ends up launching that same marketing technique, and it ends up hurting your business. So those are the things that you're trying to protect with a non-compete. In some states, non-competes must be entered into prior to employment or tied to other specific consideration to be enforceable. So whether it be you're paying them a certain amount to sign a non-compete up front, or during the non-compete period post-termination, you're required to pay the employee during the time when they're unable to work. Again, that differs by state. And sometimes courts are able to blue pencil, like New York is willing to blue pencil these provisions. Okay, next slide.
Julie, I just think you need to address what blue pencil means.
Okay, so blue penciling means that the court is willing to take the existing language in the agreement and modify it so that it's in compliance. So, for example, if your non-compete was requiring the employee to not work for a competitor for a year, they might say, okay, that's not reasonable in scope, so we're going to modify it to 6 months because we feel like that's reasonable. Or geographic scope. Maybe they had a nationwide geographic scope. You can't work for a competitor in the United States. And so the courts may modify that to say, okay, maybe it's the geographic scope is where the employee service customers of the employer. So some courts are willing to blue pencil. Some courts will throw the entire provision out. And obviously that's not preferable to the employer. You want to have something in place. So the ability to blue pencil is something that's a positive for employers. So I just want to touch upon New York, since that's where we're located, and sort of what's required for New York courts. I kind of touched upon this in the beginning of the presentation, but New York courts have found that employment or continued employment is sufficient consideration, so you don't have to pay additional compensation in exchange for the signing of the non-compete. And if the restrictions will be upheld in the non-compete if they're reasonable, but courts heavily scrutinize and disfavor non-competes in New York. So you want to make sure that you are researching what's required and staying within those limits. Generally speaking, to be enforceable in New York, employers must show that the restrictions are reasonable in geographic scope, reasonable in duration, are necessary to protect a legitimate interest of the employer, do not place an undue hardship on the employee. Obviously, that's not something the courts want. They want to make sure that the employee has the ability to earn a living, and it's that the non-compete is not harmful to the general public. So if by preventing this employee who has some unique skill set to go to a competitor, and that restriction is harmful to the general public because he has a skill that the public would be interested in, then the courts may be willing to deem those provisions unenforceable. Okay. Intellectual property. So, all right. So for intellectual property, and again, this depends on the type of company that you have and the types of things that you're interested in protecting. from employees. Usually it can apply during the employment, but most of them focus on the post-employment termination. And the goal is to require the employee to disclose a few things. So require the employee to disclose at the onset of employment any developments or creation previously created by the employee, and define that as property owned by the employee. And the reason we do this is because if it's something that the employee created prior to employment or even during employment that has nothing to do with the employment, or maybe it's similar, but it's something that they created outside of work hours and not using any of your intellectual property, then you want to make sure that you're identifying that up front and identifying that as owned by the employee, so there's no questions later on or no disputes later on. So the employee can't say 6 months into employment or even after they terminated, hey, well, I developed all these things and they're mine, so they're not considered intellectual property of the company. So by identifying them up front, at least the company can be aware of what's out there and, kind of set it aside until they end up terminating or until a dispute arises. Address of use of employee-owned IP. You want to be careful with that, because if the employee is using their own creations or development during the course of employment, then it gets questionable if they're taking something they created. Usually this is more in the software area or IP and marketing and things like that, where they've created something during the employment and they're using your marks, your products, and enhancing that product. Then there's a question about who actually owns that IP. So you want to address that up front and their ability to use that during the course of employment. Usually you want to include a work for hire provision. So that states that any products or services or intellectual property developed, or patents or inventions that are developed during employment and on behalf of the employer, will be the intellectual property of you as the employer. And along that same line, you want to make sure that the employee has an obligation to assign any intellectual property rights, including the cooperation in obtaining a patent or a trademark filing for the IP. So you want to make sure that they're required to do this and follow through, so that you're not left with a product or some type of intellectual property that you can't use, or that is open to other people using because you are unable to secure a patent or a trademark filing on it. So those are some of the things that are addressed in those provisions.
Thanks, Julie. So we're pretty much up on our hour. We took a couple extra minutes, but I think we did a good job staying on schedule. We have a couple questions already in the queue. We're going to answer those, and then we will take any more questions that continue to come on. Like I said, we will stay until we get through the questions that you're able to ask. Real quick, couple things. I'm going to put up the link to the slides in a minute. So if you want that, you can stay on for that. You will also get an email tomorrow that will have that, like I said, because it'll confirm your attendance in case you need that for certification purposes. So if you don't want to get the slides right now, you will get an email tomorrow as long as you were registered for the webinar. And then just wanted to let you know the best way to find out first about our future webinars and to get periodic updates on the various labor and employment law issues we track is to follow us on LinkedIn. So you can go and look for Horton Law on LinkedIn, or there is the exact URL that will get you there. We keep that pretty regularly updated with our writings and events and things like that that may be of interest to you all. So we're going to queue up the questions. I'm going to also post the link, as I said, to the slide. Julie, I'm going to go ahead and let you answer the first question that came in. There was a question when you were talking earlier about hourly employees. Can hourly employees be either exempt or non-exempt? I already mentioned in the chat room, yes, it is possible to have exempt hourly employees. Can you briefly comment on that while I post the link to the slides, and keep entering questions in the chat room. Anyone else, if you have them. Julie, are you there?
Yeah, am I on now?
You are now. Yep. Sorry.
Okay, sorry about that. So the general rule for the classification of an employee is that the employee is non-exempt unless they qualify for one of the overtime exemptions. The three main exemptions are administrative, professional, and executive. And there's also some additional exemptions that you may want to take into account. And this is regulated. Those are the federal exemptions. They also have exemptions by state law too. One of the exemptions that allows you to pay hourly for employees is the computer professional. And again, so you have to make sure that your state recognizes that exemption. But generally speaking, that exemption, the employee has to be developing, creating, testing computer software, computer hardware. And so there's a full definition of what qualifies under that. It can't be just a network person or somebody like a help desk person, and then that they have to meet the hourly rate criteria, both under federal and state law. So you do have the ability to pay those those employees hourly as exempt, and they would get the straight time for all hours worked.
Yeah. And the other example I can think of that might be generally applicable is there are certain professional employees who aren't subject to the salary requirement under the FLSA. So doctors, teachers, and lawyers are exempt from that requirement. So you could pay those employees theoretically hourly as well, depending again on what state laws might say. In New York, there's actually no salary requirement for any professional employees, although you would still have to satisfy the federal requirement for professional employees other than doctors, teachers, and lawyers. So again, it's kind of tricky because you're always balancing the two different sets of laws, assuming you're in a state that has its own minimum wage and overtime laws.
Correct.
A couple other questions that came in. One I was gonna try to address was, if you're an at-will employer and employee fails to meet hours or training requirements, do we have to send them a letter of intent or give them 30 days to get back in good standing? With the caveat that I'm not sure what state you are in and whether it's possible that state has some peculiar statute, peculiar to me anyway, that I'm not familiar with. I would say that technically, just based on that question and without considering various other facts and circumstances, if they fail to meet an hour or training requirement, then you are able to discipline up to and including termination. Of course, you can't do it for an illegal reason, which means you can't treat some people differently that might happen to fall into one, characteristic or another, men versus women, or racial or age differences, but generally speaking, they're not legal requirement to give someone notice before you terminate them. But that being said, if it's a state certification requirement, it is possible that there's some attendant state law restriction you would also have to consider. Julie, do you have anything else to add on that?
I would just say with that, it also depends on how those requirements are presented to the employee. So if there are conditions of employment, meaning, you had, like, for instance, employer or attorneys have certain CLE requirements that they have to meet, or education requirements that they have to meet to maintain their license, then in that case, as long as it's a requirement of the job, so I have to maintain an active bar membership, then I think as long as you say that up front, or in other cases where they have updated engineering things, stuff like that, then I think you'd be safe with, as long as they didn't meet it by a certain time frame where you told them in the employment agreement, then I think you're fine.
Right. I mean, obviously, if you have a policy that says if you don't meet this requirement, then we're going to give you 30 days notice to get in good stand, then you need to follow that policy. If you want to change the policy, and assuming there's no law stopping you from changing the policy, you'd want to do it prospectively, and not to disadvantage someone who's already stuck in that situation. We have one more question that had come through, so I just want to throw this out there as the warning for anyone who is still on the line and has a question. Go ahead and type something in, even if it's I have a question and I'm typing it out, or something like that, or if you submit part of your question and then submit the second part, but just don't miss the opportunity here. So the other question that came in is, what protection does an employer have for bad mouthing by a former disgruntled employee who divulges issues of a confidential nature? Julie, you want to take a first shot at that one?
Sure. You just have to be careful with a violation of the NLRA, which allows for concerted activity when employees or ex-employees are talking about terms of conditions of employment, and they're discussing it together. So in a social media forum where somebody is, on Facebook, and they're, bad mouthing the employee or the employer because they don't pay enough, or the workplace conditions are bad, something like that. When it comes to confidential information, if the employee is divulging, those can be protected, and you would have a right to do that, but you have to make sure that you have a policy that prevents them from doing that, and you explain what's considered confidential and what they can and cannot do. But the NLRB regulates this, and there are certain things that an employer has a right to protect, and the structure of that agreement has to be very particular.
Yeah, just two more points I was going to add is, in addition to the NLRB, which is the one that's most frequently or most broadly available, there would also be possible whistleblower protections if what the person is reporting is a legal violation or something along those lines, or they're talking about a complaint they made of harassment or something, then taking action, even including trying to enforce a confidentiality agreement, could potentially violate whistleblower or anti-retaliation laws. The way the question is written, I think is right. Whatever protection you have is going to be mostly limited by what you already had in writing that the person agreed to during their employment or at the beginning of their employment. But also there is the possibility of a defamation lawsuit against the employee if they're actually lying and causing damage to the company. I mean, if someone just were to publicly start claiming that the company had done something that the company clearly did not do and can prove it did not do, and that statement by the former employee is costing the company damage to their reputation or loss of business or something like that, you might just have a defamation lawsuit where you wouldn't technically have to have any sort of signed confidentiality protection or anything like that up front. The problem with that, enforcing confidentiality agreements and making defamation claims against former employees, is that former employees may not have that much money, depending on why they're former employees. If it's that they weren't good enough to be employed and they don't have other employment and they're not otherwise well off financially, then it's only going to be but so good to have any rights against them anyway, because you might not be able to get anything out of it. But obviously, if you have a former executive employee who is doing something, then they might have more wherewithal and they might be able to cause more damage. So it might be more worthwhile to actually try to enforce some potential rights. So with that, I don't see any more questions in the queue, but I will keep this open for another moment to see if any questions do come in. We appreciate everyone attending today. Hope you picked up a few helpful pieces of information as you look at your employment agreements or decide when and whether to use them in the future. All of our contact information is now on the screen if you need to follow up with us. And then I just want to point out, especially for those of you who this is your first time joining us, we try to do nearly monthly webinars like this in pretty much the same format on a host of different topics. We are based in New York, so many of them are focused on New York law, but not all of them. Some of them, like this one, are broader in coverage, and others relate to various federal labor and employment laws that come up. So that's kind of an overview of what you might expect if you want to attend our future webinars. I don't see any more questions coming in. Julie, you have any final thoughts? Did you mute yourself?
Can you hear me?
Okay. I can now.
Okay, sorry. The only thing I would say is if for those of you who are signed up to receive our our law firm alerts and are interested in certain topics, like Scott said, we do try to do these webinars quite frequently. If you have a topic that you're interested in, I would encourage you to reach out to us and let us know, because we do these often, and if there's something in particular that you're interested in, chances are that some of our other clients are interested as well.
Yep. Okay, well, I don't see any more questions. A good number of you have stayed with us throughout the entire time today, so I appreciate that. Look forward to working with you in the future, and in the meantime, we hope you have a nice afternoon. Take care.